Hello everyone, today's topic is going to be on the alternate dispute resolution mechanisms, simply called as the ADR, and they are nothing but a set of methods that facilitate the courts to manage the problems of high blockage of cases and to provide speedy justice and dispute resolutions. As the word suggests, alternate dispute resolution systems are a substitute or an alternative to the traditional or conventional dispute resolution process. ADR mechanisms are generally available for civil and commercial matters. The types of alternate dispute resolution are negotiations, mediation, conciliation, and arbitration. In negotiation, the parties, along with the counsel, shall exchange their grievances along with their terms and come to a solution in an amicable manner with no third party. In India, negotiation does not have any recognition through any of the legislation per se. Initially, which is called as the BATNA, nothing but the best alternative to a negotiated agreement, and the VATNA, the worst alternative to a negotiated agreement, is set. The ground rules such as the length of the sessions are set, then the exchange of information by the parties related to the matter to clarify the misunderstandings and the confusions. Next is the process of bargaining and problem solving. Upon a successful completion of the negotiation, an agreement based on the terms is agreed upon and is drafted and well settled. Mediation is a voluntary negotiation process where the parties are assisted by a third neutral party who would assist the process to be in a much more structured manner. Mediation is completely a private mechanism where the details of the process cannot be disclosed without the prior consent from the parties involved. The steps to the mediation process. First is the appointment of the mediator by the parties, either mutually or through the court. A memorandum on the issue is sent to the mediator by the parties 10 days prior to the session. The mediator then meets the parties either separately or together. Then the agreement on the agreed solutions is signed, which is also sent to the referral court. Upon the satisfaction of the court, a decree is passed on the agreement. If not, the case is referred back to the referral court. In conciliation, the conciliator first only facilitates the parties to come to a conclusion. Though the process sounds so much similar to that of the mediation, the conciliator here has the powers to issue the orders and decisions, unlike a mediator. The process of conciliation. First, it is the invitation to participate in the conciliation process is sent. Upon the mutual agreement, conciliators are appointed. Written statement is submitted by the parties. Arguments are made either written or oral with the parties together or separately. Then the conciliator drafts the possible amicable solutions which the parties could review. Upon the agreement, the settlement agreement is decided and then finalized. Under arbitration, both the parties would refer the matter to one or more third neutral party who is known as the arbitrator. Now, the decision of the arbitrator is binding on the parties involved in the entire arbitration process. The procedure for arbitration is, first, the party who is initiating the arbitration will send a notice to the other party. Then the parties will mutually agree and appoint an arbitrator, either as per the arbitration clause in the contract or the court will appoint the arbitrator. Then one party will file the statement for the claim, upon which the other party files the statement of defense. Then the arbitration process moves on to the hearing stage, followed by filing of the written arguments. So based on these arguments, the arbitral award, which is nothing but the order, is made and subsequently sent to the parties. Now, the party in whose favor the award is made is entitled to enforce the award. Advantages of using the ADR. Less time consuming than the regular court process. The scope of expression by the parties is much higher than the scope that is present in the normal litigation process. Prevention of further conflict and helps in maintaining a good relationship with the parties. Protection of the best interest of all parties involved. To sum up, over the years, the courts have found it a little easier to manage the number of cases which are being handed over by referring them to the ADR mechanisms. It must be noted that the ADR mechanisms are beneficial to everybody, including the legal system. The propagation and higher usage of the same is thus highly important, and we must promote more and more alternate dispute resolution mechanisms to have a speedy disposal of cases. I hope this video had been useful to all of you. Thank you so much for watching.